this we can remove. Good evening. We must begin with a thank you to our friends in the media for being here at very, very short notice. So we begin. Just a few words of introduction, and then we'll go into the nitty-gritty for this press conference, which will be conducted in English and Hindi. So, in the Lok Sabha and in the Rajya Sabha, 300 MPs belonging to about 20 parties, including independents, 300, all these parties, anti-BJP parties, moved notices in Lok Sabha and Rajya Sabha for the first time since independence against the Chief Election Commissioner, to remove the Chief Election Commissioner. Out of those 300 MPs in two houses, what was actually needed was 100 from Lok Sabha and 50 from Rajya Sabha, 150. But over those 2-3 days in Parliament, we didn't want to use any digital signatures, so we used physical signatures. 193 was the number. Add to 193 about another 110. So somewhere in the region of 300 plus. Who were these parties? I'm not giving you the numbers of these parties, but who were these parties? The Indian National Congress, the All India Trinamool Congress, the Samajwadi Party, DMK, AAP, RJD, Shiv Sena UBT, NCP SP, that is NCP SP, CPIM, CPI. And there were Aam Aadmi Party. Then I'm going again. RSP, RLP, KC, MDMK, BAP, VCK, JNK, NC, CPIML, JMM, IUML, RJD, did I say? So all these parties, I may have by mistake left out. MNM, KCM, I may have left out one party, but basically 300. Some of these parties are represented here today, and the only reason the others are not represented because they could not catch a flight. So we have today, from my right, the Delhi representative of the DMK, Yogesh. So when we spoke to the DMK parliamentary leadership, he was the only person here. So thank you for being here. On my right is Member of Parliament from Aam Aadmi Party. That is Dr. Sandeep Pathak. Then I'm going across to my extreme left. Again, this is Rajiv Jha, NCP SP. He's based in Delhi, so it was easy for him to come. Javed and Professor Ram Gopal Yadav of SP were both trying to get here, but they said they'll reach in 45 minutes, so no, we're trying. CPIM, CPI, IUML, you know where they are. They're all busy with the Kerala elections, but we spoke to Mr. Baby last night about this. Everybody's on board. Then we have Sagarika Ghosh, the Deputy Leader of the Trinamool Congress in Rajya Sabha. You all know, and Member of Parliament, Manoj Jha. And we have Dr. Abhishek Manu Singhvi, representing the Congress Party, and he will address this press conference from here onwards in English and Hindi. And again, thank you so much for being here.
Friends, thank you for being here at short notice, and thank you to Mr. Derek O'Brien for being the Sutradhar for so many parties and so many people coming together on a cause which is important for the nation, for democracy. I will address you in English and then in Hindi, so please be patient. We will not take any questions on any topic other than directly related to impeachment. So friends, we are here today because, and this is important, because when accountability is adjourned indefinitely, then democracy itself stands impeached. And that is our concern. if truth on the side of the CEC or the EC is so strong, why fear scrutiny? If the system is so clear, why do the majority party and all those other supporters, why try and bury the motion unseen? So I will give you in simple ways the constitutional, the legal position to tell you why, and we are in the political sphere, we are in the court of public opinion, we are not in any courtroom. We are in the court of thinking people who believe that democracy and constitution matters most, and we are speaking to them through you. So the first point I wish to make is, there are of course many errors, fundamental errors of approach in the order which we received a couple of days ago from both houses, the presiding officers, and both the orders are virtually identical, almost identical to the comma full stop, some minor differences here and there. The first and the fundamental difference in approach, fault line in approach, fundamental conceptual error, misunderstanding of our constitutional ethos is this, that you have forgotten that our framers, far wiser than us, created a procedure which was an adjudicatory process followed by a political process, both collective, and you have substituted it by telescoping it into the opinion of one person, the presiding officer of each house. That is completely antithetical to the architecture of what was created by our framers and founders in respect of impeachment. Now recently there was a judgment in the so-called Yashwant Verma case by the Supreme Court. The court there itemized that impeachment has roughly 6 stages. The problem with this order is that it ends everything at the first stage. It strangulates all the 6 stages, it telescopes all the 6 stages as if that power, that architecture, that sequence at the threshold can be so narrowly looked at only by the presiding officer. If this approach is followed, you tell me, how will you ever go in impeachment to a committee? How will you ever go to the collective process of parliamentary wisdom? So the 6 stages which the Supreme Court has told us are, first, the admission stage, which is where we are on this order now. It has been rejected at the admission stage. The second stage would be the formation of the committee. The third stage would be the formulation of charges by the committee. And remember, the committee has adjudicatory, pure full court powers. Top Supreme Court and High Court judges by designation by the Act of Parliament. It is not just anybody, it is not a partisan body. That formulation of charges. The fourth stage is a report of that committee under an Act of Parliament. The fifth is a discussion on that report. Now remember, at the fourth stage, if the committee says that I am innocent, then the matter ends. It doesn't go to the fifth stage. But if the committee finds, then the fifth stage is discussion in Parliament, a collectivity, the collective wisdom of the sovereign entity of this country, the temple of democracy, Parliament. And finally, if the Parliament holds in a particular way, then the presidential order, impeaching, disposing, dismissing, removing. Now, what has happened here is very extraordinary. The order notes that all the procedural, all the requirements under the rules, all the requirements under the system have been fulfilled, in fact more than fulfilled. Many more than 50 signed in the Rajya Sabha, many more than 100 signed in the Lok Sabha. And it notes that there is no problem with that. I am giving you how the principle for statement purposes is correctly stated and then totally abused, totally misapplied. Second thing it notes correctly is that I, the presiding officer, am only supposed to take a prima facie view, which means I have to see if it is an order. I have to see that we are not writing anywhere 2 plus 2 is 5. I have to see that there is no charge saying that I tried to buy the Taj Mahal. Prima facie things are in order. It says so. So the test is correct. It then proceeds completely wrongly, to hold a full mini trial. It takes his charge, it gives the opinion of the presiding officer on that charge. You don't have to be lawyers. Common sense tells you that in every charge, if he is the presiding officer and he gives a view, then there can never be impeachment. It cannot be per se by definition an impeachment, because it will not go from his stage to stage 2 to the committee. The committee will not decide, it won't go to stage 3, because he has given his view. He has not done it except by paying lip service to prima facie. He has done it by saying prima facie and then giving a full mini trial on the merits of the charge. This is completely wrong. Ironically, in para 8, that order of the presiding officer quotes a Supreme Court judgment. The Supreme Court judgment which it quotes is Ravichandra Iyer, a judgment of 1995, which recognizes that the committee, which is the adjudicatory process, an independent judicial, top judiciary, judges. So adjudicatory process plus a political process. The whole thing is telescoped into one person's unilateral view. So the Supreme Court said this, which is quoted in the order rejecting our motion. Parliament sparingly resorts to the mechanism of impeachment designed under the Constitution by political process.
Yes.
You short circuit it. Very easy to short circuit it. You don't allow the political process to start. As the extreme measure only upon a finding of proved misbehavior. That's the adjudicatory process. Finding of proved misbehavior or incapacity recorded by a committee constituted under section 3 of the Act. Should that also be short circuit? You kill it at the inception, at the threshold. So the impeachment process is reduced to the decision of one person. It eliminates any further scrutiny by the temple of democracy, by an adjudicatory body appointed by the Supreme Court or in consultation with the Supreme Court. In this application or this distorted application, you can have never any accountability. And remember, some of these posts, Supreme Court judge, EC, are deliberately kept away from normal accountability. I can file an FIR against him. I can file a complaint against him or take some action departmental against him. Against a Supreme Court judge or a CC, I can't do it. Because they said, look, you deserve to be insulated, so we'll make it more difficult. Now the more difficult can't be impossible. The more difficult is adjudication, then parliamentary, and then removal, after a basic looking at the threshold stage. But if you kill it at the first stage, then it becomes impossible. The only remedy of impeachment is nullified. Did the constitution makers ever, did Baba Sahib, whose anniversary is coming next week, did he ever imagine that you would put certain things in the hands of a single person to an extent where his accountability would be reduced to zero? Para 7, by the way, formulates the test correctly, calls it prima facie. In fact, it's very interesting. Para 7 is a sentence. And if you apply this sentence, I don't understand how this reaction could come. I'm reading not me, I'm reading the Honorable Chairman. I have to apply the test that if every statement stated in the notice of motion is believed to be true, notice of motion given by us, he says, I have to apply the test that if every statement stated in the motion is believed to be true, would it amount to prima facie case of misbehavior? So it is what lawyers technically call demurrer. You assume what is said to be true and then come to the conclusion that it cannot constitute misbehavior in the most extreme sense. Can our very serious charges pass that test? I'll give you examples why it cannot. One of the charges we made, is called charge 2, was that in a actual approach and asking for material in respect of a huge controversy about deletions in a particular place in India, we wrote repeatedly to the EC and the CEC. Electoral fraud issues were raised regarding Mahadevpura Assembly constituency. What we wrote is here that we found voter fraud and we gave evidence of 11,000, 40,000, 10,000. We've given the figures here. Instances of misuse of Form 6, etc. Now the charge is that the CEC approached the whole issue from inception in an adversarial, threatening posture. He publicly demanded that the leader of the opposition, A, it's in quotation, submit a signed affidavit within 7 days, B, quotation, or apologize to the nation, C, quotation, there is no other third option. Now this charge will be wrong or right. We have made a very specific charge, you can't get more, and I don't think any of the predecessors of this Honorable CEC have said in this manner, this posture, this tone, this tenor, this body language. The reply given by the Honorable chairman in this doesn't answer this. The reply is in para 19. I'll read it for you. I mean, I'm sorry, this is a little long and boring, but that's, you have to understand what is going on.
No.
Second charge, he says, he summarizes the charge. Then he gives the answer. After summarizing the charge, which I just told you. Sorry, there was one more part to this charge. A identical allegation about voter fraud had been made by Mr. Anurag Thakur regarding Raebareli. So the second point was that you cannot have what is sauce for the goose is sauce for the gander. You cannot have a discriminatory and partisan. None of these words, you must apologize, you must give an affidavit, there is no third option, were uttered in respect to Mr. Anurag Thakur. That is also our charge. Now see the answer on the charge in the order. It needs to be appreciated, this is the order I am reading, that the Chief Election Commissioner and other Election Commissioner are undertaking a very sensitive and delicate work which necessarily involve political parties. If any allegation is made with regard to the functioning of the Chief Election Commissioner or any other member of the Commission, it is desirable that such allegations or misgivings are dealt with during periodic press conferences which have been taking place for several decades. Nobody is objecting to that. This ensures transparency in the functioning of the Election Commission, no problem. Differences of opinion on the appropriateness of such responses in the absence of clear and demonstrable evidence of abuse of authority or unlawful conduct cannot amount to misbehavior so as to warrant his removal. Apart from the fact that there is no credible evidence to substantiate the allegation of this charge, they are merely speculative or unsubstantiated. Now where is the answer to what I just now said? I said you told the leader of the opposition, this man, to apologize. I said you told this person to file an affidavit. And you said there is no third option. And this man here, you never asked any of these questions. Now where is the answer to that? This is the entire charge 3. That's what happens when you don't have a committee of judges. That's what happens when you don't allow this whole parliament collectivity to do. Take another example, charge 6. The charge in a nutshell was that, and I happen to be appearing in those cases, that yes, ultimately you looked at Aadhaar, you looked at, there were many allegations, we all know that SIR, but 2 allegations in particular were that in SIR you should at least look at Aadhaar. And the second allegation was that give us readable lists of deletions. I mean, I would say that in democracy they are almost uncontestable requests. But we had to bang our head, it never happened. We went to the court. The court had to pass 3 orders, judicial orders, the dates are given, before that Aadhaar was added as a secondary document in the list of documents by the EC. And the deletion lists to be supplied in a readable format took a similar long time of repetitive court intervention. This is the charge number 6. Para 23, that charge number 6 is summarized, then para 23 supposedly purports to answer that charge. No answer is the answer given. The answer is no answer. The 6th charge is regarding contempt and non-compliance with Supreme Court direction, where it has been alleged that the Election Commission on multiple occasions failed to comply with the direction. Now nobody is saying that the Election Commission can tell the court, go to hell, I will not comply. Of course they have to comply, there is no option. They complied. Our allegation was that it took 3 orders and 3 months before they started complying. So we are showing the conduct of the CEC. And for deletion, similarly, for the, giving a readable copy of deletion list. The material available in the public domain concerning SIR clearly indicates the Supreme Court is presently seized of these issues, including those relating to ongoing revision of electoral rolls. Well settled that in judicial proceedings, particularly those involving the constitutional rights of citizens to be included, the court may issue interim directions which are binding on all concerned. Any alleged deviation is appropriately addressed to the court's established contempt jurisdiction. This is what is known as delightful nothings, vague generalities. First of all, there is no answer to the 2 points. I give you very specific points. Second, it is wrong because contempt may be valid or fail. Impeachment has no connection with contempt. Impeachment is a process totally distinct. Sub judice may go on or not go on. Impeachment is not a bar there. What is this answer? So SR will go on for 3 years, or there will be 20 people complaining in courts against this CEC. Parliament cannot impeach him because those pending proceedings are pending. I'd like to see this law. I'd like to be educated. The sovereignty and the integrity of a separate constitutional procedure, independent, autonomous, called impeachment, is sought to be subjected to or subordinated to either sub judice or contempt. There is absolutely never this kind of an approach. There is a 5th point. I'm being very specific. If there is any answer, if I'm wrong, somebody can tell us. The Supreme Court order, which I read to you in the Yashwant Verma case, has a para 6.2. The 6.2 para says, if I can get it, I'm not very good at these technicalities, but it says that you must consult. I'm sorry, it's here. Yes, it's here. Just give me a second. I have the para. I want to give you the actual para. This is the Supreme Court saying. The Speaker or the Chairman may either admit or reject the motion after, quote, consulting such persons, if any, as he thinks fit, and after considering such materials, if any, as may be available to him. So he has the discretion. Let us assume that. But in this order, pray tell us, did you consult anybody? Certainly not us, the complainants. Now, if you consulted this lady, the first person you had to consult was us, we were the complainants. If you consulted this man, you can consult him. He may be partisan. He may be this way or that way. But you will not consult the complainants who have brought the entire action. Now, this order passed by the Honorable Chairman is significantly silent on any consultation. With whom, when, if, how, nothing. You have to presume there was no consultation. Maybe there is internal consultation with officers, somebody who wrote the report, somebody who attested the report, somebody who advised the report. That is not consultation contemplated to have a wider view, especially if you are the only solo person doing it, not having parliament, not having committee. You have therefore, in conclusion, done a mini trial. You have strangulated the adjudicatory and the political process, and you have mixed up sub judice, contempt, impeachment, all illegally. तो दोस्तों, ये बहुत गंभीर मामला है. आज संसद की गरिमा पर साया पड़ा है. सत्ता पक्ष चुनाव आयोग पर सवालों से इतना क्यों घबरा रहा है? सत्ता पक्ष प्रस्ताव ठुकराने का हर प्रयत्न करता है, सच को झुठलाने का प्रयत्न करता है सत्ता पक्ष, और आप इस प्रकार से लोकतंत्र का गला घोटने का प्रयत्न कर रहे हैं. मैं संक्षेप में कहूंगा, अंग्रेजी मैंने बोल दिया है. मूल रूप में जो आपका अप्रोच है इस पूरे मुद्दे पे, वो संवैधानिक रूप से गलत है, कानूनी रूप से गलत है, सोच में विकार है, अप्रोच में विकार है. क्या विकार है? आप ये भूल गए कि हमारे बहुत बड़े बड़े माइंड्स, मस्तिष्क, इस देश की विशेष संपत्ति जो बैठी थी संविधान असेंबली में 3 साल तक, उन्होंने जो आर्किटेक्चर बनाया है इन प्रावधानों का, इम्पीचमेंट का, उसमें सोच बिल्कुल भिन्न थी. सोच थी कि हाँ, प्राथमिक रूप से आप देखकर ऐसे मोशन को एडमिट करेंगे, नहीं करेंगे. वो प्राथमिक रूप पे देखने की प्रक्रिया, ये देखना होता है कि वो उसमें सही आंकड़े हैं, उसमें जो बहुमत है 50 या 100 का वो सही है, किसी का हस्ताक्षर फौर्ज नहीं है, किसी का नाम गलत नहीं है, कोई आदमी मृत नहीं है, इत्यादि इत्यादि. उसके बाद ये भी देख सकते हैं आप कि 2+2 5 नहीं लिखा है, कोई ऐसी भयानक अजीबोगरीब चीज़ नहीं लिखी है कि ताजमहल खरीदा जा रहा है, बिक रहा है. इस सब को देखने के बाद इसमें प्रक्रिया में सबसे बड़ा योगदान 2 चीज़ों का होना चाहिए. पहले उस न्यायिक समिति का, जो एक्ट ऑफ पार्लियामेंट, हमारे संविधान ने कहा कि पार्लियामेंट बनाएगी इस एक्ट को. आपने पार्लियामेंट को दरकिनार कर दिया. ये एक्ट बनेगा पार्लियामेंट द्वारा, ये तब कहा गया संविधान में, और उनका हम नहीं बना रहे कि प्रक्रिया क्या होगी, आप बनाएंगे. और उस एक्ट को आपने संवैधानिक स्टेटस दिया. उस एक्ट में कहा है कि कमेटी बनेगी. वो कमेटी सिर्फ सुप्रीम कोर्ट और हाई कोर्ट जजेस की होगी, न्यायिक होगी, निष्पक्ष होगी, बाहरी होगी, आंतरिक नहीं होगी. उस प्रक्रिया के बाद एक जाएगा राजनीतिक प्रोसेस में, राजनीतिक प्रक्रिया में सामूहिक रूप से इस देश की सबसे महत्वपूर्ण गणतांत्रिक बॉडी संसद निर्णित करेगा। इस तरह के 6 स्तंभ उच्चतम न्यायालय ने माननीय यशवंत वर्मा जी के केस में सूची दी है। पहले मैं कंप्लेंट करूंगा, प्राथमिक रूप से वो एडमिट करेंगे या उसको निरस्त कर सकते हैं जो मैंने कहा कारणों पे। उसके बाद समिति बनेगी, समिति चार्जेस बनाएगी, चार्जेस के बाद सुनवाई होगी और एक निर्णय आएगा। निर्णय के बाद वो संसद में जाएगा, वहां डिबेट होगा। उसके बाद अगर समिति ने वहीं खत्म नहीं कर दिया या संसद ने नहीं सोचा कि खत्म करना है, तब माननीय राष्ट्रपति उसको निरस्त करेंगे। ये तो कुछ भी नहीं हुआ, इस कुछ करने का प्रयत्न भी नहीं किया गया। इसको एकदम शुरुआत में ही ये निर्णय दे दिया जिससे ये 6 की 6 सभी प्रक्रियाएं खत्म हो गई, अवधारित हो गई। बीच में एक टेलीस्कोप होकर एक छोटी प्रक्रिया बन गई, माननीय अध्यक्ष महोदय का निर्णय। ये हमारे निर्माताओं की कभी सोच नहीं थी, न हो सकती है। इसमें देखिए कोई और हल नहीं दिया गया कुछ लोगों के लिए एक्शन लेने के लिए। कुछ लोगों को स्तर पे रखा गया हमारे संविधान निर्माताओं द्वारा। उच्चतम न्यायालय के जज हैं ये, चुनाव आयोग के मेंबर हैं ये, कुछ और भी लोग हैं, सीएजी हैं। इन सबको हमने कहा कि मैं इनके विरुद्ध एफआईआर फाइल कर सकता हूं, उनके विरुद्ध एफआईआर नहीं कर सकता। इनके विरुद्ध में डिपार्टमेंटल इंक्वायरी शुरू कर सकता हूं, उनके विरुद्ध नहीं कर सकता। क्योंकि हम एक बहुत बड़ा महत्वपूर्ण गणतांत्रिक व्यापक प्रक्रिया दे रहे हैं इम्पीचमेंट का। तो उस इम्पीचमेंट वाली प्रक्रिया को अगर आप असंभव कर देंगे, इम्पॉसिबल कर देंगे, तो फिर तो वो जवाबदेही से बाहर हो गए। ये सभी लोग जवाबदेही से बाहर हो गए। ये राजनीतिक प्रोसेस जिसके पूर्व एक न्यायिक प्रोसेस होगा, ये उस निर्णय में भी रिकॉग्नाइज्ड है, लिखा है, जो इस रिपोर्ट में, अध्यक्ष महोदय की रिपोर्ट में पैरा 8 में लिखा गया है, रविचंद्र अय्यर का, जो मैंने अंग्रेजी में पढ़ा, कि इट इज अपॉन अ फाइंडिंग ऑफ प्रूव्ड मिसबिहेवियर बाय अ जुडिशियल कमिटी फॉलोड बाय अ पॉलिटिकल प्रोसेस। ये रविचंद्र अय्यर का पैरा 8 में लिखा गया है ये निर्णय इस और आदेश में। और अगर आप ये अपने अंततोगत्वा इस लॉजिक पे चलेंगे तो कोई भी इंपीचमेंट प्रोसेस हो नहीं सकता, क्योंकि सब कुछ बहुमत पे आधारित होता है। बहुमत हमेशा उसको शुरुआत पे खत्म कर सकती है। और आप जहां पर एक विशेष प्रोसीजर दिया है जो आसान नहीं है, उसको आप असंभव बना रहे हैं। 2-3 त्रुटियां जो साफ हैं, मैंने पैरा 7 बताया, जहां की टेस्ट सही दिया गया है, जो कसौटी है वो सही लिखी गई है कि प्राइमा फेसाए प्राथमिक दृष्टिकोण में मैं देखूंगा। लेकिन उसके बाद उसको जो लागू किया है वो एकदम गलत रूप से किया है। हर मुद्दे पे 6 या 7 चार्जेस पे पूरी एक लघु ट्रायल, मिनी ट्रायल की है। जैसा कोई न्यायिक जज करता, जैसा वो सुनवाई करके कोर्ट कचहरी में होता है, उसको करते हैं आप। वो तो कभी अगर ये होता है तो फिर आप मिनी ट्रायल शुरू में खत्म कर देंगे, फिर वो जज वाली कमेटी क्या ट्रायल करेगी। चार्ज नंबर 2 में 3-4 मिनट और लूंगा। चार्ज नंबर 2 जो है, उसमें कहा आपने कि हमने 2 उदाहरण दिए थे चार्ज नंबर 2 में जो आपने लिखे हैं। एक तो कि जब हमने महादेवपुरा के विषय में आपसे मांगी जवाब, तो आपने बड़े सख्त शब्दों में, जो किसी भी संवैधानिक पदासीन व्यक्ति के लिए शोभा नहीं देते, कहा कि आप माफी मांगिए देश से, एफिडेविट फाइल करिए, और कोई तीसरा ऑप्शन नहीं है,
तीसरा विकल्प ही नहीं है।
विकल्प तीसरा हो ही नहीं सकता। ये कोटेशन दिया है हमने, ये कोई मेरा इमेजिनेशन नहीं है। उसी वक्त रायबरेली के विषय में माननीय अनुराग ठाकुर जी, जो एक मंत्री महोदय रह चुके हैं, उन्होंने भी एक बहुत बड़ी मांग की कि यहाँ गलत है, ये फ्रॉड है, ये है, वो है। उनसे तो कोई एफिडेविट नहीं मांगा, उनको तो नहीं कहा कि आप माफी मांगिए। तो हमने लिखा, अभी गलत हो सकता है, सही हो सकता है, लेकिन इसका जवाब आता है पैरा 19 में, जहां एक शब्द नहीं लिखा है इस मुद्दे पे। ये जवाब है वो प्रक्रिया वाला कि जवाब नहीं देना है, ये जवाब विहीन है, एक शब्द इस मुद्दे पे नहीं लिखा है। इसी प्रकार से चार्ज 6 में हमने कहा कि बहुत सारे एसआईआर में प्रॉब्लम रही, लेकिन 2 मुख्य बातें जिससे मुख्य सीईसी की पूरे उनकी छवि पे एक बहुत बड़ा प्रश्न चिन्ह उठता है, वो है आधार के विषय में और रीडेबल डिलीशन लिस्ट देना, जिनको आप डिलीट कर रहे हैं उनकी चेकेबल कंप्यूटर द्वारा रीडेबल लिस्ट दीजिए। पहले वाले मुद्दे पे 3 उच्चतम न्यायालय के आदेश आए, मैं खुद पेश हुआ उनमें, 3 महीने लगे। उन आदेशों के बाद बहुत ही एक रुकावट के साथ अंततोगत्वा उन्होंने एक सेकेंडरी सूची में डाल दिया आधार कार्ड में। पहले नहीं डाला, दूसरी बार नहीं डाला, तीसरी बार के बाद डाला। दूसरा, डिलीशन लिस्ट को रीडेबल देने के लिए, मतलब ऐसी चीज तो गणतंत्र में मांगने की आवश्यकता नहीं होनी चाहिए, मेरे हिसाब से मांगने की आवश्यकता नहीं होनी चाहिए, अपने आप देना चाहिए स्वतः। वो बोले रीडेबल, तो उससे बेहतर लिस्ट दीजिए। उसके लिए महीने निकल गए। ये हमने कहा और इसका जवाब आया पैरा 23 में, वही जवाब विहीन जवाब। एक शब्द नहीं है आधार या डिलीशन के सामने, मैं पढ़ूंगा नहीं आपको बोर करने के लिए, मेरा पूरा मैंने पढ़ दिया पिछली बार अंग्रेजी में। एक शब्द नहीं है, तो आपने निर्णित किया कि मैं जवाब दूंगा, जवाब नहीं देंगे। एक और मुद्दा है कि उच्चतम न्यायालय ने, जो मैंने यशवंत वर्मा जी के निर्णय की बात की, पैरा 6.2 में लिखा है कि दी प्रिसाइडिंग ऑफिसर में कंसल्ट whomsoever any person he thinks fit, appropriate, etc., etc. मैंने पढ़ा था अभी। इस पूरे आदेश में कहीं ये इंडिकेशन नहीं कि किसी को उन्होंने कंसल्ट किया, यानी विचार विमर्श किया, प्रश्नोत्तर किया। अगर करना होता और लिखते किया तो प्रथम व्यक्ति जिससे कंसल्ट करना होता कम से कम वो याचक होता। हम याचक हैं, हम याचक करता है, हम कंप्लेनेंट हैं, हमसे तो नहीं किया। किसी और से क्या लिखा नहीं है इसमें। पैरा 6.2 में ये अपेक्षा होती है कि आप करेंगे किसी से, नहीं किया। और ये लघु ट्रायल करके आपने संसद की गरिमा में एक छाया डाली है। आपने मुद्दों को, जो सब जुडिस विषय कहते हैं, जो निलंबित हैं कोर्ट कचहरी में, या जो कंटेम्प्ट हो सकता है, उनका मिश्रण कर दिया है इम्पीचमेंट प्रोसेस से। ये संविधान के हर विद्यार्थी को मालूम है, पहले वर्ष वाले विद्यार्थी को, कि इम्पीचमेंट का प्रक्रिया एक भिन्न न्यायिक एवं राजनीतिक प्रक्रिया है, उसका कोई संबंध नहीं है। यानी उदाहरण के तौर पे आप अवमानना के कार्रवाई में पूरी तरह से मुक्त हो सकते हैं, फिर भी वही व्यक्ति उसी चीज के लिए इम्पीच हो सकता है। आप सब जुडिस हो सकते हैं 5 मामलों में, उससे कोई व्यवधान नहीं है आपको इम्पीच करने के लिए। इसका भी मिक्सअप किया है इस ऑर्डर में, लिखा गया है पैरा 21 में, ये तो सब जुडिस है। तो मैं अंत करूंगा अपनी बात धन्यवाद करके। ये देश के 300 व्यक्तियों की रिप्रेजेंट करने वाली प्रतीकात्मक पार्टियां हैं। ये इनिशिएटिव लिया है तृणमूल ने और डेरेक ओब्रायन जी ने, और सब इस एक जनहित के राष्ट्रीय मुद्दे पे साथ आए। ये संवैधानिक मुद्दा ही नहीं है, कानूनी मुद्दा ही नहीं है, ये लोकतांत्रिक मुद्दा है, ये संसदीय मुद्दा है, और इसलिए इसको इस स्टेज पे इस तरीके से रद्द करना बिल्कुल गलत है।
1 or 2 questions related to this, focused on this.
So what will be your next stage to counter this objection?
Well, we are not at liberty to disclose either political or legal strategies, but you can take it that if within 2 days we have given you a comprehensive response as far as the bar of public opinion is concerned, then we have other remedies to the maximum extent that we can move. We will be invoking them. I don't think it will be right for me to disclose or reveal, but you can rest assured that whatever is permissible within the contours of law, constitution, we will do. This will not be allowed to be resting just the way it is being dealt with.
In this case, is there any permission to go to court?
I have given the same answer. नहीं, अभी भी बात हो रही है, बात चल रही है। हाँ, यहाँ रख दीजिए। नहीं, प्रश्नोत्तर चल रहा है ना।
Any more? हाँ, एक मिनट,
इनको करने हैं।
एक मिनट,
ये
हाँ,
कह रहे हैं,
बताइए।
क्योंकि एसआईआर के मुद्दे का भी इसमें जिक्र किया, और वो भी एक वजह बना इस इम्पीचमेंट मोशन के पीछे, नोटिस के पीछे 27 लाख लोगों के नाम बंगाल में कट गए हैं। इस पूरे मामले पर संयुक्त विपक्ष क्या करने जा रहा है, क्योंकि अब तो वो वोट नहीं दे पाएंगे।
मैं इसका बहुत उत्तर दे सकता हूँ, लेकिन ये प्रश्न इम्पीचमेंट से नहीं संबंधित है।
हाँ,
अब वो देखिए, किसी भी न्यायिक प्रक्रिया को आप पूर्वानुमान से निश्चित नहीं कर सकते, न करना चाहिए। वो उपयुक्त नहीं होता है। हम समझते हैं कि अधिकार क्षेत्र है, अधिकार क्षेत्र को कैसे उपयोग किया जाएगा, कैसे उसको रिवोक किया जाएगा, वो बात की बात है।
Last.
So that means I must impose, if that is correct, I will either impeach the whole election commission or none. Who says so? I hope there are 3 human beings there, not all 3 rolled into 1 human being.
He told you he didn't consult.
And do you think that every other election commissioner would like to lose his identity into a single person?
Thank you so much.
Thank you.
Thank you.
Thank you.